Good morning and welcome to this Evershed Sutherland PROPcast. I'm Anna Woodford, professional support lawyer to the real estate practice group here at Evershed Sutherland. Our subject today is an introduction to development consent orders. I'm joined this morning by Laura-Beth Hutton, who is a partner in our real estate practice group who supports clients with planning and infrastructure consenting. Hi, Laura-Beth.
Hi, Anna.
Hi. So let's start at the beginning. What is a development consent order?
So, a development consent order, or DCO, is a type of consent which authorises certain developments of national significance, known as nationally significant infrastructure projects, or NSIPs for short. The requirement for a DCO was established in the Planning Act 2008, which put in place a requirement that for certain types of development and infrastructure, where relevant thresholds are met, a promoter must seek a DCO in order to have a lawful consent. Any other type of consent for these developments wouldn't be lawful.
So what types of development need a DCO to have a lawful consent then?
The types of projects which may constitute an NSIP are set out in Section 14 of the 2008 Act, and I won't list them all, but this includes, for example, the construction or extension of a generating station, installation of above-ground electric lines, certain types of highway development or airport development, rail freight interchanges, and wastewater treatment plants. And then the subsequent sections of the Act set the thresholds for each type of development that, when met, mean that a DCO must be sought. So, for example, if a proposed rail freight interchange is a certain size and meets certain other requirements, like being connected to the national rail network, it needs a DCO. In cases where the thresholds aren't met, or if a development is of national importance but isn't one of the types of development listed in the section, a developer can make an application to request that a Secretary of State gives a direction for that project to be treated as an NSIP under Section 35 of the Act if it meets certain criteria.
And what are those criteria?
Very briefly, because it can get a bit complicated, but it's they are that a development is or forms part of a project in the field of energy, transport, water, wastewater, or waste, or is a business or commercial project of a prescribed description. The Secretary of State must think that the project is of national significance either by itself or when considered together with one or more projects in the same field. And then there are some geographical criteria as well. So, for example, in England or its territorial waters. And when those criteria are met and a Section 35 direction is given, the project will be subject to the DCO application process. So a developer of a significant commercial project might seek a direction, for example, if that project is particularly complex or might require multiple consents or span several local authority boundaries, for example.
You mentioned that England was a criteria. Does that mean that you can't have a DCO in Wales?
No, you can. The NSIP regime does apply in Wales, although some of the thresholds are different. So the generating capacity for an energy station is higher in Wales than it currently is in England. But the Section 35 direction option specifically applies only in England.
Okay. So what does it mean to have a DCO consent? What does that sort of consent include?
So an NSIP project will ordinarily be supported by national policy. And what I mean by that is that there's a suite of national policy statements, or NPSs, which apply to most types of NSIP development, so energy, transport networks, ports, etc. And those NPS outline national policy for those types of development, and they generally then create a presumption in favour of that development where policy requirements are met. So obviously an NSIP starts with a very strong starting point of that policy presumption. The content itself is a statutory instrument, so a form of secondary legislation. And this means that the consent is a piece of law, not only a planning permission. The beauty of a DCO is that it can provide not only the planning consent for a project, but may incorporate other consents and licenses and could include, for example, authorisation for compulsory acquisition of land and rights if certain tests are met. And for that reason, the DCO is often referred to as a one-stop shop. Applicants look to include in the DCO as many consents and approvals as they can in order to carry out the development. And because it's a piece of legislation, this means that the DCO can also disapply, apply or modify certain types of legislation and grant additional consents which may be required for the project, such as the actual consent for the carrying out an operation, the inclusion of compulsory acquisition powers, which I mentioned before. You can include powers to enter land to carry out surveys or protective works. You can include discharge consents or powers to undertake and carry out street works, highway orders, footpath diversions, etc.
So a DCO can cover any consent at all, really?
It can include a lot, and the powers can be very wide-ranging, but there are some exclusions, and sometimes you need agreement from relevant bodies to include certain consents. So, for example, with the drainage consents that I mentioned, the lead local flood authority would want to be satisfied with the measures within the DCO that relate to that discharge consent. But also, there are some which are less successful. So if a developer wanted to include, for example, an environmental permit in the DCO, that is legally possible, but you do need approval from the Environment Agency to do that, and the EA don't tend to like giving that approval. So there may be some consents that you still need to seek outside of the DCO, but the idea is to try and build in as much as you can. And obviously, the inclusion of those powers then is very beneficial, so that a developer doesn't need to go and seek those consents separately after consent has been granted. And another example of this is that we would often build into a DCO provisions which are the equivalent of highway agreements. So the developer doesn't need to then go and negotiate a separate Section 278 agreement with the Highway Authority after the DCO is granted in a way that they ordinarily would with a planning permission.
You said earlier that the DCO isn't a planning permission. So what does that mean, and how does the DCO consent actually work?
So the DCO contains powers to do certain things and then provides the consent to carry them out. It will then also include certain provisions which might refine or constrain how those powers and consents can be delivered. For compulsory acquisition, for example, it will generally include provisions which govern how the powers can then actually be exercised. It might limit certain acquisition powers in relation to particular parcels of land, for example, and it will deal with the service of notices in relation to those powers. The DCO will also contain what are referred to as requirements, and they are similar to planning conditions that you would get on a planning permission. And they tend to require, for example, the discharge and approval of certain other matters, either through the submission of further details or compliance with a management plan, for example, during construction or operation of the project. You would ordinarily negotiate those requirements with statutory bodies and the local authorities so that those bodies are also happy that there are adequate controls on the face of the DCO to make sure the developer is complying with those in carrying out and operating that development. And then finally, another element I wanted to highlight was that a DCO will also typically include what are called protective provisions, and they set out arrangements and govern the mechanisms that are required to protect the interests of certain statutory undertakers and other affected parties. They're very heavily negotiated usually between those parties, and the aim of them is to try and balance the competing interests of protecting an asset of a statutory undertaker and also the ability to bring forward the consented development, which is obviously, as we've already said, a nationally significant project and therefore very important infrastructure to come forward.
And what does the DCO application process entail? What does a developer have to do to get a DCO?
So to start with, an application for a DCO is determined by a Secretary of State rather than local planning authorities. And it will be the Secretary of State who's responsible for the nature of that type of development that's the subject of the application. So, for example, the Secretary of State for Transport would determine a DCO for a highway or an airport. There is perhaps, unsurprisingly, a plethora of legislation and guidance relating to the DCO process, considering the nature of the consent that's probably to be expected. And this guidance and legislation relates from anything dealing with pre-application consultation, detail on what the application has to include in terms of particular documents or plans, and then also how an application is actually examined and determined. So I'll just summarise the process, and I will try and keep it short because there is quite a lot to it, but bear with me. So the process is very much a front-loaded approach. So the developer or promoter is expected to carry out extensive consultation in relation to its proposed development before submitting that application to the Planning Inspectorate, or PINS, and they examine the application on behalf of the Secretary of State. So during the pre-app process, a promoter is going to refine its scheme, consult with prescribed statutory parties and the local community, and engage with PINS through their pre-app service. The timing of this front-loaded element tends to vary, but it's typically between at least 18 months to maybe 2.5 years. So we've dealt with the pre-app, we finally get to submit our application, and we come to a process called acceptance. And this is essentially where the Planning Inspectorate consider the state of the application, the type of engagement that is being carried out, and essentially they validate the application and say that it's ready to go for examination. They have 28 days to do that. And there's then a period where interested parties can register and make what are referred to as relevant representations. And PINS are basically then going to get ready for the examination. Again, this period is varied. It's not a statutory period, but it's usually around 3 months. It can be longer, sometimes it can be shorter. And then the application is going to be considered by what is called the examining authority. And this can be either a single inspector or a panel of inspectors. And they will take up to 6 months to examine basically the application. And it's a largely written process, although they do normally have several hearings. Perhaps anything between 6 to 10 hearings is round about the norm. So they have 6 months to examine, and once they've closed the examination, they then have a period of up to 3 months to write up a recommendation report to their relevant Secretary of State. And that will obviously include their findings and conclusions on all important and relevant matters, as well as what they think about the actual DCO itself. And then finally, we're in the decision period, and the Secretary of State has up to 3 months normally to consider the recommendation report and make its decision, although they can get that period extended if approved by Parliament.
Sounds very much like a sort of front-loaded process. Can you tell us a bit more about the pre-application process?
Absolutely, that's right. The NSIP regime has always had a very much front-loaded process with significant pre-application consultation and engagement with consultees. And this is because PINS are keen that the issues are dealt with as much as possible before you come to submit the application, so that the examination can focus on really key matters. In fact, last year, PINS established a new formal pre-application service and prospectus, which refocuses very much on the requirements and expectations for DCO applications, particularly during that pre-application phase. There is quite a lot of detail in the prospectus, so I won't go into that, but some key points are that, first of all, an applicant has to choose a level of pre-application service from PINS. So while they can choose the level of service, this obligation is mandatory. There's no sort of, we don't want any service, you've got to choose one. And those tiers are basic, standard, or enhanced. And then there's an annual fee payable, and the level of that depends on the service of tier chosen. There's also quite a few new requirements or documents, and these include, for example, an issues tracker and what they've called a PADS, which is a principal area of disagreement summary statement. And again, these are documents which are intended to try and outline and highlight issues that a project might have or that an applicant is progressing with, and agreeing relevant issues with the relevant consultees. There's also a new milestone before submission of an application called the adequacy of consultation milestone, and this is where PINS consider the extent of the pre-application consultation that an applicant has undertaken and decide whether or not any further engagement is required. So with those two, you can really see that there is a massive focus on pre-application engagement and consultation, and trying to iron out any outstanding matters that you might have with consultees or the community in particular. And then it's also worth mentioning there is what is called a potential fast track process. Now, I think that title is a little bit misleading, because what that does is really place more emphasis on the pre-app process or the pre-app stage and the amount of engagement that needs to be undertaken. The theory being that then that might allow for a potential shorter examination up to 4 months, although that shorter examination isn't guaranteed, but it's worth knowing about.
So it seems like engaging with consultees is a really key part of the process.
Absolutely. As I mentioned then, I mean, you can imagine the extent of matters a DCO application needs to deal with. And this is because the resulting consent is a powerful document. So PINs want to be satisfied that they've heard the relevant statutory consultees' positions, which means that engaging in particular with statutory consultees on a relevant matter is key. So, for example, if an NSIP project engages habitat regulations matters, PINs will want to hear from Natural England. They'll want to understand what Natural England's position is. And obviously, the more an applicant has been able to engage and agree matters for Natural England, it's more likely the examining authority will have fewer concerns about those issues. They do, of course, still need to examine the issues, but if they can be happy that Natural England is content, then ultimately life should be easier to examination in that regard. Engaging with the local community and affected parties is also really important, and it would be necessary to have an effective consultation strategy, which will include public exhibitions, for example. It's absolutely vital. And this is again because due to their nature, the projects that they're very large, they're big scale, and they do have potential to have impact on the local community. So again, the applicant will always need to undertake and take very seriously the consultation with the community and those parties. And PINs really do want to be satisfied on that basis.
So what would you say the benefits of a DCO are?
Well, as I mentioned earlier, the DCO consent is a very powerful tool. So we've spoken about the one-stop shop and the ability to include lots of consents, including, for example, compulsory acquisition. This can help provide, obviously, a lot of certainty in terms of land assembly for delivering these important projects. I would also say the DCO regime has a number of benefits for both applicants and interested parties, although they might not see it that way. But the structure of the process, for example, is, with its clear examination deadlines, which do apply to all parties, is intended to provide some certainty and can be particularly important, obviously, given the cost and risk associated with delivering large-scale infrastructure projects. Although there have been many delays in recent years in the actual decision-making process, but the process is intended to give that certainty. And ultimately, a decision is made on the consenting of what is nationally important infrastructure at national level, so by central government rather than the local authorities. In theory, hoping to ensure cohesion in national infrastructure planning, but also deliver what, again, has been set out in national policy as important infrastructure and development.
And on the flip side, what are the complications or risks involved with the DCO?
Well, given their nature, the projects, of course, entail many complexities. They're naturally quite legalistic. They include a lot of parties, and they are time and cost heavy. There does also tend to be a lack of consistency around how applications are dealt with at examination. So, one examining authority might choose to focus on different issues than another examining authority. So it's quite difficult to track how examining authorities are dealing or considering certain matters. Again, due to the nature of the projects, they can have an impact on local communities, and this does, and we are seeing this more and more, result in community action groups who like to take a quite active role in the process, and in particular at examination. So that can obviously have quite an impact in terms of dealing with those submissions and also engaging with those parties. I think the other risk, of course, is that an application can be recommended for refusal by an examining authority. And this might be where they, for example, consider that there was just too many unresolved issues at the end of the examination and they couldn't get happy with the consent in the end or the approach. And this then tends to mean that the Secretary of State will undertake perhaps further rounds of consultation during its decision period. And then sometimes that leads to, or quite often that leads to an extension in the actual decision date, and therefore you're looking at a bit more delay, so that you do have that uncertainty around it.
Thank you. You mentioned earlier that a DCO is sometimes called a one-stop shop. Do you still need a Section 106 planning obligation when you have a DCO?
Yeah, so the Section 106 obligation document itself wouldn't be part of the DCO consent. So it would be negotiated and concluded alongside the DCO, but it won't be within the actual DCO. But in short, you probably would have a Section 106. Yes, if planning obligations are necessary for the development, then you would have a 106 agreement or a unilateral undertaking to accompany the consent, and ideally be completed before the end of the examination.
You said ideally there. Does that mean you can deal with a Section 106 after the examination?
In theory, you could conclude Section 106 agreements or obligations beyond the examination period, but in my opinion, that would be a risk. Depending on how long after the examination was concluded and that it was concluded and submitted to the authority. And the reason for that is that the examining authority needs to take account of the 106 obligations when writing its report. So if they don't have a concluded agreement or undertaking, then they can't do that. So my advice would always be to try and submit a dated deed before the end of the examination so that all parties are clear on what the application commitments are.
You've talked about conditions or requirements being put on a DCO. Sometimes planning permissions are personal. Is that the same for DCOs?
It can be, yes. Lots of DCOs tend to be expressed as personal consents. So, for example, major highway schemes will be personal to national highways, or overhead electricity lines will be personal to national grid. Um, and that's pretty commonplace, and you can understand the reasons for that. Some DCOs though are deliberately not personal consents and have and need to have the effect for the benefit of those with the interest in the land, and this tends to be probably your more commercial schemes, but and that includes your rail freight interchange DCOs, for example. A promoter of a rail freight DCO will want their future occupiers of their warehousing to be able to have the benefit of the order, and therefore it's not beneficial. There would be no benefit in having a personal DCO in that regard.
And once the final decision has been issued, can you appeal if you're not happy with the outcome?
No, you can't appeal a DCO in the same way that you can for a planning permission. So you can only challenge the decision in the courts on a point of law, and that applies to all parties, whether that's the developer, local authority, or community action group.
And how long does someone have to bring a challenge if they did want to pursue it?
6 weeks.
So, looking now to the future, you mentioned the new PINS prospectus. Are there any other reforms on the horizon?
Yes, along with the many other planning reforms that have been announced recently by the government, the NSIP regime hasn't been ignored. So last year there was a review undertaken by Lord Banner KC into the legal challenge side of NSIPs. And that review made a number of recommendations to try and streamline the process for judicial review of a DCO. And that was really looking to try and minimise the delays that are caused by what can be or have tended to be unsuccessful legal challenges. So obviously at the same time needing to uphold the UK's constitutional principles, trying to make sure that we're reducing the impact of delays, uncertainty, when actually what we're trying to deliver here is nationally significant infrastructure and development that the country needs. So the government has confirmed it's going to be taking forward those proposals to streamline the permission stage, in particular for judicial review challenges. And this will mean that applications for permission will be heard at an oral hearing rather than having an initial paper permission stage. And for any cases that are deemed totally without merit, then that refusal will be final and can't be appealed. The government also published recently a working paper called Streamlining Infrastructure Planning, and that had two key objectives. So, firstly, was to have clearer and stronger national policy, so making sure that the NPSs are updated more regularly. I mentioned the NPSs earlier, and many of those were published and adopted many years ago when the process first came out, and so they were getting pretty old. And so the idea is that the government wants those to be reviewed and updated more regularly, so that we've got up to date policy when we're determining or when they're determining the DCO application. And then the second objective was to try and have faster decisions under the NSIP regime. So I've spoken a lot about timescales, and some of those are statutory, but there is also lots of delay, even where the timescales are statutory. So we'll obviously, I'm sure everybody promoting a DCO will be very keen to understand what those faster decisions might look like. The working paper also talks about trying to reduce the need for what they call gold-plated consultation. So again, I've spoken a lot today about pre-application engagement and consultation with statutory bodies, with the local community, with affected parties. And there really are a lot of boxes to tick in that regard, and that's still very important. But what the government want to do is to try and rebalance and improve the quality of that pre-application consultation, rather than making it so constrained that an application can fail at acceptance if a certain tiny box hasn't been ticked, for example. Obviously, we'll be looking out for the detail in the upcoming changes, which we're expecting to be introduced through the promised Planning and Infrastructure Bill, which I understand is due to be introduced to Parliament today. So obviously, we'll be looking out for that.
Oh, well, thank you, Laura-Beth. That's been a really useful oversight of DCOs, and it will definitely be very interesting to see what reforms are introduced and the impact that they have on the process.
Thanks,
Well,
Emma.
that brings us to the end of this Evershed Sutherland PROPcast. Thanks, everybody, for listening.